Next to the reporting procedures, there are complaints procedures. And these are very important, not just because they provide concrete remedies in specific situations or even for specific individuals in a case, but also because they provide the treaty bodies in particular the opportunity to develop international human rights law by means of showing how particular provisions that are laid down in instruments come to be applied in concrete situations. And of course, the application of the law to specific cases, to specific facts, is what provides the law the power to actually change things on the ground. Individual complaints will continue to be a part of our conversations for the next weeks. When we look at the European, the American, and the African system, all of which in fact have human rights courts that provide also such individual complaints procedures and that do look into specific cases. And this includes, in their case, making legally binding decisions on state parties whether there has been a breach of human rights obligations in a concrete case. But for now, we will focus on the UN system, and their complaint procedures do not actually give rise to legally binding decisions, although they are quite authoritative, in particular when it comes to the treaty bodies and their decisions. Now, there is a big gap or a big difference between the kind of complaints that are being launched on the one hand before the Human Rights Council and on the other hand before the UN treaty bodies. I firstly want to look at the charter-based complaint mechanism, which is in fact quite unique in international human rights law for a number of reasons. Firstly, it is confidential in the sense that the sessions before the Human Rights Council, which basically deal with the case, are conducted behind closed doors, and that includes the working groups as well as the session actually of the Human Rights Council, in which eventually then recommendations are made. The second aspect to take into account is that this procedure is in fact one that targets more generally systematic or gross patterns of human rights violations rather than strictly speaking individual cases, which may however also be communicated. When it comes to the charter-based complaint procedures, formerly known as the 1503 procedure, there's a deliberate and explicit focus on the broader context rather than just the individual case. The process is described in quite some detail in the textbook, but just briefly, we firstly have an individual or an organization such as NGOs, and this makes sense, we are looking at systematic kind of violations here, launch the case, which is then pre-screened by the Office of the High Commissioner and two working groups that will also look whether there is actually a well-founded claim and whether there is, in this sense, jurisdiction, so to say, for the Human Rights Council to look at this issue. The two working groups, so the working group on communications and the working group on situations, then sort of go through the process in which they are in contact with the state who provides a report, a response to the allegations, and then recommendations are being formulated that are then discussed in a closed plenary of the Human Rights Council. The Human Rights Council then comes to a decision and usually recommends some sort of action, which, for example, can also lead to the appointment and creation of special procedures. So you have then follow-up procedures, such as one of the ones discussed in the previous videos, which are installed in order to monitor the situation as it unfolds. The treaty-based complaints procedures, on the other hand, are quite different. Indeed, as already mentioned, here we have individual communications. So it is an individual with a particular human rights grievance that launches, files a case before one of the human rights treaty bodies in respect to the treaty in question. Compared to the charter-based mechanisms, we of course have more jurisdiction questions here. And that's not just because not every state has ratified every human rights instrument, as I already mentioned in the previous video, but also because, in fact, for the individual communications to be able to be filed, a state party needs also to have ratified an optional protocol to the instrument. So what often happens, even I would say in a majority of cases, is that states, yes, they ratify the substantive part, the actual instrument, such as the CRPD, such as the CERD, but they do not actually join the optional protocol, and therefore individual communications cannot be filed. However, if they have ratified the additional protocol in question, what comes about is a so-called quasi-judicial procedure, which means that it resembles very much a judicial proceeding, as it would be, for example, before the European Court of Human Rights. The difference, of course, is that the actual final decision or observations or views, as they are sometimes called, are not actually legally binding, even on the specific state that is faced with the claim. Other than that, however, the procedure very much resembles a court procedure. The committee in question needs to have jurisdiction, temporal, territorial jurisdiction. All the domestic remedies will have to have been exhausted before the national legal framework before a case can be filed. And there is an actual proceeding with equality of arms, meaning that the state who is being alleged of a human rights violation will be informed of the allegations, will have the opportunity to respond, and there will be a sort of examination, in some cases even a public hearing, to determine whether the allegations are actually factual. The various complex steps that are a part of this procedure are very nicely laid down in the flowchart on page 396 of the textbook. And obviously I will not be going through the whole steps here, but I just want to mention that it is because of the procedural nature of these individual communications that they are basically being treated in the literature, in human rights scholarship, like cases before a human rights court. So just to summarize, and this of course is basically the answer to the reading question, if you look at the charter-based complaint procedure, we have one that is focused on gross systematic patterns of human rights violation. It is confidential and it can be filed by various actors, including individuals, but also NGOs. And on the other hand, if you look at the treaty-based complaint mechanisms, this is about individuals claiming their rights before one of the committees in respect to the instrument, which gives rise to a much more public, much more proceduralized, and so to say, quasi-judicial proceeding. That said, the outcome of neither procedure is legally binding, and that of course is one of the distinguishing features of the regional human rights courts that we will be talking about in the following sessions. This concludes the videos for this week. I look forward to discussing the various aspects with you in class.